You're answering Justice Jackson's question, though. I have the same one, right? Aren't you asking whether the judgment was, I mean, how did it hurt your client that Whole Foods wasn't in the case when, you know, your friend on the other side is pointing out that nothing in the case turned on Whole Foods or its evidence? Put aside the jurisdictional point for now.
And I appreciate the point. My point was simply to be that the lack of the state forum in a single proceeding in which both defendants could be brought within the same proceeding is itself prejudicial.
So I take it it's a very abstract prejudice in the same way that your friend on the other side said it's abstract. It didn't really affect the outcome. You're not saying the outcome would have been different. You can't point to anything like that.
That's the jurisdictional principle. That's right, Your Honor. With respect to practical prejudice, as a practical matter, the way this case was litigated with Whole Foods out of the case, there was no opportunity for the plaintiffs to develop the evidence that they would have developed about the role of Whole Foods in actually making express misrepresentations about the quality of the baby food at issue. And so it is true that as the case was tried, it was tried solely based on the quality of the product. But that was an artifact of the erroneous ruling, an erroneous eerie guess made by the district court about the content of state law that should have been a determination made by the state courts consistent with the congressional scheme.